Okay, AB673 Penalties for Late Wages. So here's what's going on. Apparently, there are many employers that are paying their employees late. So when you have a scheduled payroll date, say like for me, I have semi-monthly, that's twice a month. They get paid on the 7th of the month and the 22nd of the month. If I don't meet my payroll obligation and make sure that my employees are paid on those dates, I am subject to these late wage violation penalties. And this is so easy. And here's the thing, a lot of people don't understand this with the internet. Employees know what the laws are. They know. Even guys that work on cars know. Okay, even though that they're not techie per se, they know what the laws are. So all they have to do for this is go to the labor commissioner and say, hey, I got a late paycheck. What can you do? And this is not final paycheck, because that's a whole different thing, because final paycheck has to be paid day of, or within 72 hours of when the person if they walked off the job.
What's late for this? What's considered late?
Any day past the due date of the payroll. So tell me when your payroll dates are.
The 15th and last day of the month.
Okay, so if that payroll is not made on those dates, that's considered late. So if the payroll comes out and they're paid, say, 2 days later, the 17th, then that is subject to a $100. And guess who gets that? The employee gets that. Yeah. Yes.
So this 72 hours, even though we fired them, they have a 72 hours time period to pay them?
Well, if you fire them, you have to have their check then, right on the spot. You have to hand them their check. Okay, and if you don't, that's a whole different penalty. 1 day, for every day late that they get their final check, they get 1 day of pay. So say it's like okay, so here's an example. My son-in-law used to work for Safeway some time ago. He had worked there for, I don't know, 15 years. And you would think Safeway, they're a big company, they do everything right. No. No. He had to go to the labor commissioner to get his final check.
Really?
Yeah. And so 30 days it took him. He finally went because he was asking.
Pay for free.
Yeah, he got 30 days pay because he went to the front of the labor commissioner and they ended up not showing up because they knew it was wrong.
Yep.
And he got 30 days pay. But still, you know, you don't want to be hanging on the edge of your seat for that long.
This just starts January 1st?
Yes.
Yeah, I had an employer, believe it or not, back in like 2002, this is exactly what they did. And everybody ended up quitting on that because they would never pay us on time. So I'm really glad to see that that's doing that.
Yes. And that's what a lot of these laws are about, is protecting the employees, because employers will take advantage. Now, I understand too, because, you know, cash flow is an issue for small businesses. It really is. But, you know, to me, my payroll, that's primary before everything else. Payroll is first. Yes.
Is that $200 taxable to the employee?
Yes. Yes, it is.
So you take $200 and then you take out payroll taxes.
Yes.
There you go.
Well, because it's earned income, right?
I was wondering how they would declare it. Like, if they do it 3 times, they get $600. Give them a 1099.
Well, here's what's going on. No. So you see that subsequent violation here? Subsequent violation.
$200 per employee.
200 plus 25% of the late amount. So if their paycheck, say their paycheck is $500, that's $125 plus 200. So, and it depends, and then the other thing is you have to think about, the labor commissioner can negotiate whatever they want to in terms of how they deal with it. And if they think that people are being, this is something conscious that they're doing deliberately, they're going to have a heavier hand. Or if they feel if the employer's been in business for a long time, I've seen this happen. The employer's been in business for a long time, they have a lot of employees, but they don't have anybody watching the store on their back office. They will hammer that company. I am not kidding. I have seen awards for obscene amounts of money for things that otherwise probably wouldn't have even had to pay anything. So they're really paying attention to this. Okay, no rehire limitations. And this is really about settlement agreements. This is AB749. And this is a provision when you have a settlement agreement with an employee. And this is usually done in a court of law. So hopefully your attorney is going to know this. If you have to go to court and do a settlement out of, say you don't want to go to court, you do a settlement agreement in advance, you cannot put a no-hire provision in there, if you can believe it or not, unless they are, you know that they are guilty of sexual harassment, or that they are a bad performer. So this doesn't affect you, like if you wanted to, say for example, you wanted to terminate someone for cause, this doesn't apply. So this law does not prevent an employer from terminating an employee that doesn't perform, or as long as it's not for, it has to be for a non-discriminatory or non-retaliatory purpose. You can't stand on this if you want to retaliate against an employee for going to the labor commissioner.
So, I know I worked for a company that's, that basically when we handed them their termination letters, it would say, whether or not they were allowed, eligible for rehire.
Yes, it doesn't apply to that.
Okay.
This is only for settlements. Only for settlements. That's why I bolded it. That's why I bolded that. Settlement agreements only. Okay? Flexible spending accounts. Anybody have FSAs at their workplace? Okay, you now are required, as of January 1st, you must notify your employees before it comes to the end of the year, not the end of the year, but the end of the plan year for the FSA. So say you're on a fiscal year, your plan ends on the end of September. You need to give them a sufficient notice, 2 different forms, not just one, and there's the different ways that you can notify them, that so they have time to get money out of that account, because it's a use it or lose it. If they don't get it out, they can't use it.
So that's only use it or lose it accounts, not the rollover accounts.
Right, and it does not apply to plans governed by ERISA. Okay? Yeah, you're welcome. So you can send them an email, you can call them, you can text message them, you can send them a letter in the mail, or you can tell them one-to-one, or you could do a staff meeting. That's a good way to do it. As long as you keep an agenda, you need to have documented proof, because if you don't, they can say, I never knew. You didn't tell me. So I'm just saying, documentation is everything when it comes to employment. Paid family leave, SB83. So what they did was they extended paid family leave as of January 1st from 6 weeks to 8 weeks per year. And paid family leave is, in case we don't know what that is, it's a partial wage replacement. The employer does not pay that. The employee pays that through their short-term disability insurance. And so, all you're doing is whether or not, you don't not even required to protect their job. And by the way, if you don't want to protect their job, you ought to have that in writing. Make sure you have a policy on that, and that it's in writing, and that your employees know in advance. Okay, harassment prevention training. SB778, state of California says, you know what? You didn't get it done last year, it's totally fine. We extended it out. You have another whole year to get it done. So if you don't have it done yet, and you have 5 or more employees, you ought to start thinking about how you're going to get that done. Now, California was supposed to provide that training, and so far, I don't know, they were supposed to put a portal online and get that all taken care of. I've only heard of one meeting that they offered, and then it wasn't very widely published when that was. So people try to go, they couldn't get in. So I don't know when they're going to have it, but that they're offering it for free. But for example, you can have it done on demand online. I offer that if you're interested, let me know. So here's what it is. It's every 2 years. So if you had it done last year, you're not required again for 2 years, okay, till 2021. So all employees, the difference is in this law, all employees must be trained. If they're non-supervisory, it's a 1-hour training. If they're supervisory, it's a 2-hour training. And it must be done every 2 years. And if you have a new employee that comes on board after you had your training done, you have 6 months to get them trained. If you have someone was an employee and a non-supervisory and they get promoted to a supervisory level, you have 6 months to get them trained up in the 2-hour training. Okay? Any other questions on that? Okay. See how we're doing on time. We are at time. We're over time.
Supervisory on that. Can you go back a minute? It said just for supervisor? Yeah.
No.
The bottom one is not
Supervisory
supervisory.
employees.
Prevention,
Okay,
oh,
so
I'm
1
sorry,
hour
yeah,
for
that's right.
non-supervisor employees.
Yeah. Yep, yep, yep,
So now my
yep. Okay, and that's been in place for that went into effect last year. Okay, mandatory retirement savings called CAL Savers, and here's the thing. This is for employers with 5 or more employees. If your company already has a 401k or a 403b, this does not apply to you. Okay? If your company has a 401k or a 403b, this does not apply to you. I just want to say that again.
What do you mean, a 401k meaning the employee can contribute to a 401k?
What I'm saying is, if the employer has a 401k set up so that employees can put money into it, this law does not apply to you. However, if you're small, and like a lot of small businesses, you can't afford a 401k, it's too expensive. So the state is now offering, because they want people to save for their retirement. The really good thing about this is there is no cost to the employer at all. The only thing that the employer must do is register with the state, what it's within their guidelines. So you can see that this year, if you have 100 or more, you have to register by June 30th. And by the way, I checked it out. This portal is active. You can register anytime you want. You don't have to wait until the deadline. You can do it in advance. And in fact, individuals, if their employer doesn't do it, they can go on and do it themselves. So anybody, and I don't know, anybody over here have more than 49 employees in their company? Okay, so you have another year and a half to register. 5 to 49 by 2022. So we have a while for the smaller businesses to get registered for that. But the whole idea is they found that the research bears out that employees that contribute to this kind, like a 401k or this kind of, this is actually an IRA. This is a Roth IRA. It's a a post-tax. So it's not saving them any money on their taxes or anything like that, and they can only It's a Roth IRA. It's post-tax. There's no fee to the employer. And the enrollment by employees is optional. It's mandatory for the employer to register, but it's not mandatory for the employee to participate. That's optional for them. And the cost to the employee is based on whatever investment they might have, and it's right around 0.08% is what the fee is on that. And it's by a third-party investment firm that helps them with, they have options on what they want to invest in and all of that. And the cap on the contribution is only 8%. So really a 401k is better if you can afford to do that, because you can put much more than 8% in. The employee can. And then you can also do matching if you wanted to do that. And that's helpful with people, with employee engagement, and also with incentivizing employees to stay with you. So any questions about that, Brian?
The employee can contribute up to 8% of salary up to a certain dollar amount?
That's it, up to 8% of their wages.
So if they make
$1
$1 million,
If they make what?
if the employee makes $1 million,
Yeah.
so So it's not like like a regular Roth IRA could put in like $6,000 a year.
Mhm.
So there's no.
No, the cap is whatever the 8% of the salary is. As far as I know, that's what I know about it. So if there is like a ultimate dollar cap on that, I'm unaware what that is, but it could be. You know, because 8% of $1 million is what, $80,000?
Yeah.
Yeah. So I don't know. I would have to dig in more. Okay, this is really important because this applies to everyone. Cal OSHA has redefined what a serious accident is. So here's why this is important. If you have an employee that has to be hospitalized, and that means more than just being hospitalized to go in for a test or an x-ray or just to be evaluated to be watched. If they're hospitalized, you only have 8 hours to report it. This is why this is important. You have 8 hours to report it because it is now a new definition of serious accident. So any hospitalization for treatment.
Is
Now,
that for work-based injury or?
yes, for workplace injury. Yeah, this is Cal OSHA. This is workplace injuries, okay? Workplace injuries or illness that they have to be hospitalized for, so any hospitalization for treatment except for a car accident, basically, that's happened on a public street, unless it's a construction zone, okay? Or if an employee is only admitted to run tests or for observation.
I have a question. So I've got automotive guys. Now, if they're taking a car out for a test drive for a customer and they get in an accident, is that technically a work-based person?
It would be, but they're not going to be under the 8-hour report.
Unless it's in a construction zone.
Unless it's in a construction zone. That's right.
In a construction.
So what you really need to be paying attention to this because this is what I know of, and I've seen this with one of my new clients. Somebody had an accident, the guy cut his finger open, had to have I don't know how many stitches in it. He didn't tell anybody. And we got a letter from the insurance, workers' comp insurance. This happened in October. We only got it like 2 weeks ago. Okay, so good thing he didn't have to be hospitalized, but if you're not paying attention, if you don't have somebody paying attention to this, it could be a big problem because if you don't report, all of a sudden now you've got fines, you've got, your workers' comp insurance may be compromised, we don't know. So you need to have somebody really paying attention to this.
But the employee didn't report it to anybody, correct?
No, but the thing is though, you need to have, certainly somebody had to know that the guy had an accident.
The hospital would have known because he had stitches, right?
Yeah, exactly. Yes.
You need to train your employees on what they're supposed to do when there is an injury.
Exactly, and that's
You
part,
need to be training your employees.
and that's
You're not
it.
safety-
They're not having safety meetings. If
Right.
you're not having safety meetings and you're not having training as part of your safety meetings, then therein is the fall down. Okay, so that's it. You have 8 hours. I'm just saying that's really, and you can report by phone call or email. And Cal OSHA is working on getting a portal set up. They don't have it yet. No surprise there.
Where is the Cal OSHA office around here?
You're going to need to look it up because I don't. Right now, I'm way out of time and we're way over. So let me go on. Workplace drug testing. Okay, so I've been told by an attorney, your best bet is if you're going to do drug testing, do it before you hire. That you're safer that way. If you feel like you need to do it, make sure you have a policy in place. And you want to make sure that, because the courts are looking at, you're discriminating against or targeting certain people because of their ethnic background or whatever, or the way they dress or whatever it is. So they wanted to make sure that they're protecting employees from being discriminated against. So you want to consider who, I say, identify an occupational health clinic and use them if you need to. And you're going to know, right? So you need to have a policy in writing, and be as transparent as you can. And you can always, let's see, I have another one. If you have reasonable suspicion for this. Thank you for coming. I'm sorry, I'm way over time here. Let's see what we else got to do. Anyway, here we are. I'm just going to say we're going to conclude by now. Oh, and I do offer a 60-minute free consultation. If anybody here would like to have a consultation, I'd be happy to help you. And you have my information on the tablets and the pens, and I have certificates if you want that. Any other questions before we wrap up? Thank you. Thanks very much. Thank you so much for attending and for your participation. I appreciate it.